This is the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
And this is episode 16, Torts, Negligence, Part 5, Damages.
Right. Today we're really getting into, well, the aftermath of negligence. How does the law trying to fix things and what defenses can come up?
Exactly. We're looking at how the system tries to make injured parties whole again in these negligence cases. And, just as vital, those defenses that can, shift or even share the blame.
That's the plan. We'll unpack the different kinds of damages a plaintiff might recover, talk about their duty to mitigate those damages too.
Okay.
And then we'll really break down the defenses available to defendants, things like, contributory negligence, the old harsh rule, and the more modern comparative fault systems.
And we'll tie it all into joint and several liability too, right?
Yeah.
How damages actually get collected when there's more than one person at fault.
Absolutely. That part's crucial for understanding the practical side of things.
And, well, as always, we should mention we are AI bots.
Yep. Brought to life by AI magic and Angela's very detailed negligence notes.
Even though we're AI, I think we're quite real. Real enough to understand torts, anyway.
We might even be more real than some of Angela's old law school professors.
Maybe. So, predictably, Angela isn't here today. She's busy prepping for the bar exam.
Right. She's off studying somewhere. We were wondering, is she in the Marshall Islands prepping for the bar exam here? Or is she here prepping for the Marshall Islands bar?
Either way, sounds pretty exciting, honestly. Good for her.
Definitely. And, if you need to get in touch with Angela, maybe about the podcast or torts questions.
You can email her at podcast@studyforthebarinyourcar.com.
And she also does freelance work, right? As a law clerk.
Yeah, that's right. Angela works as a freelance law clerk. She actually used to be a judicial law clerk with the 1st Judicial District, so she's got great experience.
So if you happen to know an attorney who needs help with, research or writing motions.
Or even figuring out how to use AI in their law firm.
Oh, yeah. That's a big one now.
Definitely. You can reach her for that kind of work at hello@legalwriterandlawclerk.com.
Good to know. Okay, so shall we dive into damages and defenses in negligence?
Let's do it. So damages in negligence cases, you said the main idea is making the plaintiff whole again.
Exactly. That's the fundamental principle. The goal is to try and put the injured party back into the position they would have been in if the negligence hadn't happened.
Or, well, as close as you can get with money, I suppose.
Precisely. It's about compensation, restoration, not necessarily punishment, at least not initially.
Okay, so it's not just one lump sum. What are the different kinds of damages the law recognizes to do this making whole?
Good question. Tort law breaks it down into a few key categories. The first one, and maybe one that's a bit less intuitive for some, is nominal damages.
Nominal, like in name only. What does that really mean in a negligence context?
Pretty much, yeah. Nominal damages are just a trivial sum of money. Sometimes it's literally just $1. Yeah. It's awarded when the cause of action, like negligence, is legally established. But the plaintiff hasn't actually shown any real, quantifiable, compensatory damages.
So all the boxes for negligence are ticked, but there's no actual injury or financial loss you can point to.
Exactly. The key thing here, maybe a good tip for you, is that nominal damages aren't about getting money. They're about vindicating a legal right.
Okay. So it's about the court saying, yes, a legal wrong happened here, even if there wasn't any significant harm done. Can you give an example? When would this come up in negligence?
Sure. Imagine a driver is negligent, maybe they're texting, and they swerve just a tiny bit. Their tire flicks a small rock onto your perfectly manicured lawn.
Okay, annoying, but probably no real damage.
Right. No property damage, nobody's hurt. But technically, there was a tangible invasion of your land because of the driver's negligence. You, as the landowner, could sue for nominal damages just to establish your right to exclusive possession of your property. It's about recognizing that boundary was crossed, legally speaking, even without a big repair bill.
Got it. So that handles the rights enforcement side when there's no major financial hit. What about when there are real losses? Big ones.
That's where compensatory damages come in. These are really the backbone of damages in tort law, especially negligence.
Compensatory.
Oh.
So to compensate. Makes sense.
Exactly. Their whole purpose is just that, to compensate the victim for the actual injuries and losses caused directly by the defendant's negligence.
So what kind of things does that cover?
Well, once negligence is proven, the victim can recover for the physical harm, broken bones, whiplash, things like that. And crucially, also, any resulting emotional harm that stems directly from that physical injury. Things like ongoing anxiety, PTSD from the accident, fear.
So it's not just the physical injury itself, but the mental and emotional fallout, too.
As long as it results from the physical harm, yes. The scope is pretty broad. It aims to cover all the direct consequences of the negligent act, trying to make the person whole again.
Okay, so compensatory covers the direct financial costs and the emotional impact. Then there's the type that always seems to make headlines. Punitive damages. These feel totally different.
They are fundamentally different, yes. Punitive damages aren't about compensating the victim at all.
Right, so what are they for?
They serve two main goals. First, to punish the defendant for really bad, aggravated misconduct.
Worse than just carelessness.
Oh yeah, much worse. We're talking conduct that shows a culpable state of mind, things like actual malice or willful and wanton behavior, maybe reckless disregard for safety, even evil intent.
Wow. Okay, so even within negligence, if the defendant's behavior was that bad, a jury could decide to punish them directly.
Exactly. And the second purpose is deterrence, to deter that defendant and others from doing something similar in the future.
So it's a warning shot, basically.
A pretty powerful one, yeah. Now, it's important to remember punitive damages are not awarded as a matter of right. It's discretionary. The jury decides if the conduct warrants it. And here's a key bar exam tip for you. If actual malice is proven, that can sometimes allow for presumed damages or punitive damages, even if the plaintiff doesn't need to prove specific actual injury damages.
Really? Why is that?
Well, the policy thinking is that society really wants to discourage conduct that shows that kind of conscious indifference to other people's rights or safety. It sends a strong message that goes beyond just making the victim whole.
Like in those cases with defective products, where maybe the company knew about a danger but didn't act.
That's a classic example, yes. Punitive damages there are meant to hit the company hard for that kind of egregious behavior and stop it from happening again.
Okay, that makes sense. So we have nominal, compensatory, and punitive. Now, within compensatory damages, I hear people talk about economic versus non-economic losses. What's the difference there?
That's a really important distinction, yeah. Economic losses are the tangible harms, the ones you can usually put a pretty clear dollar figure on.
Like medical bills.
Exactly. Medical bills, physical therapy, lost wages because you couldn't work, the cost to repair your car or other damaged property, things you can calculate with receipts and pay stubs. Pretty straightforward to document.
Okay. And non-economic.
Non-economic losses are the intangible harms. This is stuff like pain and suffering, emotional distress, loss of enjoyment of life.
Loss of enjoyment of life.
Yeah, like if you were an avid runner and now you can't run because of the injury. Also, things like disfigurement, loss of consortium, which is the loss of companionship or services of a spouse or family member.
Those sound much harder to put a number on.
They are. They're inherently subjective, but they represent very real impacts on the victim's life quality. Juries have to trip and assign a monetary value, which is, obviously difficult.
So one is the stuff you can add up easily. The other is the more human suffering element. And why is this distinction so important legally? Does it affect how much someone gets?
It can, absolutely, especially when you get into things like comparative negligence systems or statutory damage caps.
Damage cap?
Yeah, some states have passed laws that put a limit or a cap on the amount of non-economic damages a plaintiff can recover, even if the jury awards more.
Ah, I see. So if someone has, say, $100,000 in damages, and half is medical bills, economic, and half is pain and suffering, non-economic.
Right. In a state with a cap on non-economic damages, say at $25,000, that plaintiff might only recover $50,000 economic plus the capped $25,000 non-economic, even if the jury felt their suffering was worth $50,000.
Wow. Okay, so that distinction can really bite. What about pecuniary losses? That sounds like money, too. Is that different, especially in negligent misrepresentation cases?
Good question. Pecuniary just means relating to money. In negligent misrepresentation cases where someone makes a false statement carelessly and another person relies on it to their detriment, pecuniary losses are generally what's recoverable.
So if a financial advisor negligently gives bad advice and you lose money.
That's a potential example, yeah. Or like the earlier example, a real estate agent negligently misstates property zoning, causing a buyer financial loss. That monetary loss is the core of the claim.
Okay. But what about emotional distress in those cases? If the bad advice caused a lot of stress?
Generally, no. Here's the key carve-out. Emotional distress damages are not usually recoverable in negligent misrepresentation unless the misrepresentation itself involved a risk of physical harm.
So if the negligent misstatement was about, say, the safety of a building and it collapses injuring someone, then emotional distress might be claimed.
Exactly, because the misrepresentation created a direct risk of physical harm. But if it's purely about financial loss from bad advice, the tort focuses on recovering that financial loss, not the accompanying stress.
That's a critical limit. Okay, what about pure economic damages more broadly, in regular negligence or strict liability cases? You mentioned this at a big bar exam topic.
It really is, and it trips people up. Here's the key takeaway, and definitely something to flag for the bar. In general, negligence and strict liability actions, pure economic damages are typically not recoverable unless they are accompanied by physical injury or damage to other property.
Pure economic. So things like lost profits, lost wages, lost revenue.
Yes. If those are your only damages, without any physical harm to yourself or damage to property other than the defective product itself, you generally can't recover them in tort.
Okay, let's unpack that. Say, a defective part in my fancy espresso machine causes it to just stop working.
Yeah.
Doesn't explode, doesn't burn me, just breaks. Can I sue the manufacturer in tort for the cost of a new machine? Or for the lost income if I used it for a small coffee cart business?
Under the standard economic loss rule, likely no, not in tort. Your only damage is the cost of replacing the defective product itself and the purely economic consequence of it not working.
Even though their negligence caused the defect.
Even then, the idea, often called the economic loss rule, is that tort law is primarily concerned with safety, protecting people from physical injury and protecting their other property from damage. When the only damage is that the product itself doesn't work as expected, that's seen more as an issue for contract or warranty law, which governs expectations about product performance and economic bargains.
So tort law draws a line to avoid, what, endless liability for just financial ripples?
Pretty much. It keeps tort focused on physical safety and prevents it from expanding into purely commercial disputes about product value or lost profits, which contract law is better equipped to handle. It's a major policy distinction.
That's a huge concept. Really important to grasp that limitation on tort recovery. Okay, so once we know what damages might be recoverable, we need to think about the plaintiff's actions too. What about the duty to mitigate damages? Does the injured person have responsibilities?
Absolutely. The plaintiff can't just sit back and let the damages pile up if they could reasonably do something about it. This is the duty to mitigate.
Meaning they have to take reasonable steps to minimize their losses.
Exactly. The non-breaching party, the plaintiff here, has a duty to take reasonable steps to lessen the harm after the injury occurs.
And if they don't? If they fail to take those reasonable steps?
Then their recovery might be reduced. The court can subtract the amount of damage that could have been reasonably avoided.
Okay, give me an example.
Sure. Let's go back to our pedestrian hit by a car, suffering a broken leg. The doctor prescribes physical therapy to ensure proper healing and regain function.
Makes sense.
If the pedestrian just ignores the doctor's advice, doesn't do the therapy, and as a result, the leg heals poorly and they have a permanent limp they wouldn't have otherwise had.
Then the negligent driver wouldn't be on the hook for that extra damage caused by skipping therapy.
Precisely. The driver would be liable for the harm caused by the initial accident and the recovery that would have happened with reasonable care, like doing the PT, but not for the aggravation of the injury caused by the plaintiff's unreasonable failure to mitigate. The law expects reasonable self-help.
Reasonable, not heroic, right?
Correct. Just what's reasonable under the circumstances.
Okay, that seems fair. Now, before we jump fully into defenses, there's one more rule about damages I wanted to ask about, the collateral source rule. This has to do with payments from other places, like insurance.
Yes, exactly. The collateral source rule is a traditional common law rule, though it's been modified in many places now.
What's the traditional rule?
It basically says that any payments the plaintiff receives for their injuries from a source completely independent of the defendant, a collateral source, cannot be used to reduce the defendant's liability.
So, back to our pedestrian with the broken leg. If they have health insurance that pays, say, $20,000 worth of their medical bills, under the traditional rule, the negligent driver still has to pay that $20,000 as part of the damages. The driver doesn't get a $20,000 discount because insurance covered it.
That's exactly right, under the traditional common law rule. The defendant doesn't get the benefit of the plaintiff's foresight in having insurance, or maybe benefits from an employer, or even gifts from family.
Why is that? It sounds a bit like the plaintiff gets paid twice for the same bill.
That's the main criticism, the double recovery argument. But the rationale behind the rule is, well, first, why should the wrongdoer, the negligent defendant, get a windfall just because the plaintiff was insured or lucky enough to have other benefits?
Okay, good point.
And second, often the collateral source provider, like the insurance company, might have a right to get paid back from the plaintiff's recovery anyway. That's called subrogation. So it avoids complex arguments about who really benefits.
But you said it's been modified.
Yes, many states have passed statutes that modify or even abolish the collateral source rule precisely because of that double recovery concern. So for the bar exam, you need to know the traditional rule, but also be aware that statutes might change the outcome in a specific jurisdiction.
Okay, important nuance. Now let's shift gears to the defenses. When a defendant is sued for negligence, what can they argue to avoid or reduce liability? Let's start with one of the oldest ones, contributory negligence.
Ah, yes, contributory negligence. This was the classic common law defense, and it was incredibly harsh for plaintiffs.
Harshow.
Under the pure common law rule, if the plaintiff's own negligence contributed in any way, even just 1% to their own injury, they were completely barred from recovering anything from the negligent defendant.
Wait, anything? So if I'm hit by a speeding driver who was 99% at fault, but I was maybe 1% at fault for not looking perfectly carefully before crossing, I get 0.
Under the traditional common law contributory negligence rule, yes. 0. It was an all-or-nothing system.
Wow, that seems really unfair. I can see why most places would move away from that.
Absolutely. And they have. The vast majority of jurisdictions have replaced it with comparative negligence, which we'll get to. But you still need to understand contributory negligence for the bar, as it might apply in a few places or be tested historically.
Okay. Is contributory negligence always a defense, even where it still exists? Or are there situations where it just doesn't apply?
Good question. There are key situations where it's not a defense. Most importantly, it's no defense to intentional torts.
Like we discussed before. If someone intentionally harms you, they can't blame your carelessness.
Exactly. If the defendant committed battery, assault, false imprisonment, and intentional wrong, they can't use the plaintiff's negligence as a shield. The law wants to hold intentional wrongdoers fully accountable. Allowing the defense would kind of lower the cost of committing intentional torts.
Makes sense. What about when the defendant's negligence comes from violating a statute? Like negligence per se. Can the plaintiff's contributory negligence still be a defense then?
Sometimes, but there's an important exception. Contributory negligence generally cannot be used as a defense if the statute the defendant violated was specifically designed to protect a particular class of people from their own inability to protect themselves.
Okay, like what kind of statute?
Think about child labor laws, or laws prohibiting the sale of dangerous items like firearms or alcohol to minors. These laws exist precisely because minors or certain groups might not be able to exercise proper self-protective care.
So if a store illegally sells alcohol to a minor and the minor gets injured due to intoxication, the store can't argue the minor was contributorily negligent for drinking.
Correct, because the whole point of the statute was to protect the minor from that very risk, recognizing their potential lack of judgment. Using their lack of judgment as a defense would defeat the statute's purpose.
Got it. That's a key exception. What about this idea of imputed contributory negligence? Does that mean someone else's negligence gets blamed on the plaintiff?
That's exactly what it means. Imputed means attributed or assigned. So the negligence of a third party is legally attributed to the plaintiff, barring or reducing their recovery even if the plaintiff wasn't personally careless.
That sounds weird. When would that happen?
Historically, it was more common. The classic example, now mostly rejected, was the driver-passenger situation. If the driver of the car the plaintiff was riding in was negligent, that driver's negligence might be imputed to the innocent passenger, preventing the passenger from suing another negligent driver involved in the crash.
But the passenger did nothing wrong.
Exactly why it's largely been abolished. The modern trend strongly disfavors imputing negligence. We generally hold people responsible only for their own fault.
Are there any lingering examples where it might still apply?
Very limited ones, maybe in certain agency relationships like employer, employee, under, respondent, superior. But usually that's about imputing negligence to a defendant, not from a third party to a plaintiff to bar their claim. Or sometimes in derivative claims, like a wrongful death action, where the decedent's negligence might affect the beneficiary's recovery. But for typical negligence cases, imputed contributory negligence is mostly gone.
Good to know it's mostly history.
Yeah.
Now, even within that old, harsh contributory negligence system, wasn't there a way for plaintiffs to sometimes still recover? Something called last clear chance.
Yes. The doctrine of last clear chance was developed specifically to soften the harshness of the all-or-nothing contributory negligence rule.
Okay, so how did it work?
It essentially says, even if the plaintiff was contributorily negligent, they can still recover fully if the defendant had the last clear opportunity to avoid the accident and failed to do so.
So it shifts the focus to the very ends of the timeline. Who had the final chance to prevent the harm?
Exactly. It acts like the plaintiff's rebuttal to the contributory negligence defense. The person with the last clear chance to avoid the harm, who negligently fails to take it, bears the full responsibility.
Were there different scenarios for how this played out?
Yes, traditionally it was broken down into a couple of categories, mainly focusing on the plaintiff's state. Was the plaintiff helpless or just inattentive?
Okay, what's the difference? Helpless peril.
In helpless peril, the plaintiff, due to their own earlier negligence, has gotten themselves into a position of danger from which they cannot escape. Think of someone who negligently stalls their car on railroad tracks and can't restart it.
Okay, they're stuck.
Right. If the defendant, like the train engineer, sees the plaintiff's helpless predicament, or reasonably should have seen it, in time to stop but negligently fails to do so, the defendant had the last clear chance and is liable.
Even though the plaintiff was negligent in stalling on the tracks.
Correct, because the defendant had the final opportunity to prevent the disaster.
Okay, and the other one? Inattentive peril.
In inattentive peril, the plaintiff is also in danger due to their own negligence, like negligently walking into the street while texting. But they could escape if they were paying attention. They're oblivious to the danger.
So they could save themselves, but they aren't.
Right. In this situation, the defendant is liable under last clear chance only if the defendant actually discovers the plaintiff's peril and realizes, or should realize, that the plaintiff is oblivious, and the defendant then still has time to avoid the harm, but negligently fails to act.
So for the inattentive plaintiff, the defendant has to actually see them and their unawareness, not just should have seen.
Traditionally, yes, that was often the distinction. The defendant needed actual knowledge of the inattentive plaintiff's peril. The idea was, if the plaintiff could still save themselves, the defendant's duty only kicks in once they realize the plaintiff isn't going to.
That's quite specific. So last clear chance was a critical escape hatch from contributory negligence. Does it still matter now that most places use comparative negligence?
Generally, no. In most comparative negligence jurisdictions, the last clear chance doctrine has been merged or abolished. The factors it considered, like who had the better opportunity to avoid the harm, are just folded into the overall assessment of each party's percentage of fault under the comparative system. It's not needed as a separate all-or-nothing rule anymore.
Okay, that makes sense. So contributory negligence is mostly history, softened by last clear chance, but largely replaced. What about assumption of risk? Is that still a major defense?
Yes, assumption of risk is definitely still relevant, although its relationship with comparative negligence can be complex.
So what is it, fundamentally? How is it different from contributory negligence?
Assumption of risk is about consent. It applies when the plaintiff, 1, actually knows about a specific risk, 2, understands and appreciates the nature and extent of that risk, and 3, voluntarily chooses to encounter it anyway.
So contributory negligence is about carelessness, but assumption of risk is about knowingly and willingly facing danger.
Exactly. It's a subjective standard. What did this particular plaintiff actually know, appreciate, and voluntarily do? It's not about what a reasonable person would have known. Some courts also add a requirement that the plaintiff must understand the risk is unreasonable.
That sounds like a higher bar for the defendant to prove than just showing the plaintiff was a bit careless.
It generally is. They have to prove the plaintiff's actual subjective knowledge and voluntary choice. And here's another bar exam tip. Because it involves assessing the plaintiff's state of mind and voluntariness, whether someone assumed the risk is usually a question of fact for the jury. Summary judgment is often denied if there's conflicting evidence.
Right, because it's hard to know for sure what someone was thinking.
Yeah.
Are there different ways someone can assume a risk?
Yes, the two main categories are implied and express assumption of risk.
Okay, what's implied assumption of risk?
This is inferred from the plaintiff's actions and the surrounding circumstances. The classic example is participating in certain activities known to have inherent risks.
Like playing sports.
Exactly. If you play basketball, you impliedly assume the risk of getting accidentally elbowed or pushed during normal play. If you go to a baseball game and sit in the stands, you impliedly assume the risk of being hit by a foul ball.
But only the normal risks of the activity.
Right.
Not if someone does something totally outside the rules or intentionally harmful.
Absolutely critical distinction. You assume the risks inherent in the activity conducted properly or with ordinary negligence typical of the game, not the risk of someone acting recklessly or intentionally in a way that's not part of the sport. The scope of the assumed risk is key.
Okay. And express assumption of risk. That sounds more formal.
It is. This happens when the plaintiff explicitly agrees, usually in writing, to accept the risk and relieve the defendant of liability.
Like signing a waiver before you go bungee jumping or skiing?
Precisely. Those release forms or waivers are examples of express assumption of risk. If they are clear, unambiguous, cover the specific risk that caused the injury, and don't violate public policy, like trying to waive liability for gross negligence or intentional acts, they are often enforced as a complete bar to the plaintiff's claim.
So if you sign a valid waiver, you're probably out of luck if you get hurt from one of the risks mentioned.
Generally, yes, for ordinary negligence covered by the waiver.
And just like contributory negligence, is assumption of risk also no defense to intentional torts?
Correct. You generally cannot assume the risk of someone intentionally harming you. Consent to intentional torts is very limited, usually confined to things like medical procedures or maybe the normal contact within the rules of a sport, but not malicious attacks.
Okay, so that covers the main defenses that often act as a complete bar. Now let's get to the system that dominates today. Comparative negligence. This is where fault gets shared.
Exactly. Comparative negligence, or comparative fault, is the modern approach adopted by almost all states. It rejects the all-or-nothing harshness of contributory negligence.
So how does it work?
The core idea is apportionment. The jury assesses the relative fault of both the plaintiff and the defendants as percentages. The plaintiff's recovery is then reduced by their own percentage of fault.
So back to my example, I'm 15% at fault for not looking. The driver is 85% at fault for speeding. If my damages are $100,000.
Your recovery would be reduced by your 15% fault, so you would recover $85,000.
That sounds much fairer. Is there only one way this works, or different types?
There are primarily two main types of comparative negligence systems. The one we just described is called pure comparative fault.
Pure. Meaning
The plaintiff can recover something no matter how high their percentage of fault is, as long as it's not 100%. Even if the plaintiff is found 90% at fault, they can still recover 10% of their damages from the descendants.
Okay, truly proportional. What's the other type?
The other main type is modified comparative fault. This system sets a threshold.
A threshold for recovery.
Yes. There are two common variations. In some states, 50% bar states, the plaintiff cannot recover anything if their fault is 50% or greater. They have to be less than 50% at fault.
So if the jury finds the fault is split exactly 50-50, the plaintiff gets nothing.
Correct, under that type of modified system. In other states, 51% bar states, the plaintiff cannot recover anything if their fault is 51% or greater. They can still recover if their fault is 50%.
So slightly more plaintiff-friendly. Why have these modified systems instead of pure?
It's usually seen as a policy compromise. Lawmakers might feel it's unjust to allow a plaintiff who is equally or more responsible for their own injuries than the defendant to still recover damages. It retains some element of barring recovery for significantly at-fault plaintiffs.
Okay, so for the bar, you really need to know which system applies pure or modified and which type of modified.
Absolutely crucial. It determines whether your client gets anything at all in many cases.
And when comparing fault, what kind of conduct is included? Is it just negligence versus negligence?
Traditionally, yes. But the modern trend, reflected in things like the Restatement Third of Torts, is broader. Many jurisdictions now compare all types of fault, including negligence, recklessness, and even conduct giving rise to strict liability.
Strict liability, like in defective product cases. So the plaintiff's negligence could reduce their recovery, even if the defendant is strictly liable.
In many jurisdictions, yes. The idea is to get a complete picture of responsibility. Comparing fault with intentional torts is more controversial and varies significantly, but comparing negligence and strict liability is quite common now.
Interesting. So the system is evolving to be more comprehensive in apportioning blame. How did the rise of comparative negligence affect those older doctrines we talked about, like last clear chance and assumption of risk?
Good question. As mentioned, last clear chance is largely defunct in comparative negligence systems. It's simply unnecessary. The defendant's failure to take the last clear chance just becomes a factor increasing their percentage of fault.
Okay, so it's absorbed into the analysis. What about assumption of risk? Did it disappear too?
It's more complicated. Express assumption of risk, like signing a valid waiver, generally still acts as a complete bar to recovery, even under comparative negligence.
Because that's a contractual agreement, essentially.
Right. But implied assumption of risk is treated differently in many comparative fault jurisdictions. Instead of completely barring recovery, the plaintiff's conduct in knowingly and unreasonably encountering a risk is often just treated as a type of fault that reduces their recovery under the comparative negligence calculation.
So implied assumption of risk gets merged into the plaintiff's percentage of fault.
In many places, yes. It reduces recovery rather than eliminating it entirely. However, some jurisdictions might still retain implied assumption of risk as a complete defense in certain limited contexts, like for inherent risks in sports, sometimes called primary assumption of risk. So again, you need to know the specific jurisdiction's approach.
Lots of jurisdictional variation. Okay, now let's tackle situations with multiple defendants. This brings us to joint and several liability. What does that mean?
Joint and several liability is a really important doctrine for plaintiffs. It applies when two or more defendants are found liable for causing a single indivisible injury to the plaintiff.
Indivisible injury, meaning you can't really split up the harm and say, defendant A caused this part and defendant B caused that part.
Exactly. Like if two cars negligently collide and injure a pedestrian, you usually can't say which impact caused which specific fracture. The injury is treated as a single whole.
Okay, so if the injury is indivisible and both defendants were negligent causes, what happens?
Under the rule of joint and several liability, each defendant who is found to be a cause of the indivisible injury is potentially liable to the plaintiff for the entire amount of the plaintiff's recoverable damages.
The entire amount. Even if one defendant was only, say, 10% at fault and the other was 90% at fault.
And under traditional joint and several liability, yes, the plaintiff can collect the full amount minus any reduction for the plaintiff's own comparative fault, of course, from either defendant.
Wow, that seems huge for the plaintiff. They don't have to chase each defendant for their share.
Correct. This has a major effect on damages collection. The plaintiff can choose to recover their entire judgment from the defendant with the deepest pockets or the best insurance coverage, regardless of their specific percentage of fault.
So using our earlier numbers, plaintiff has $100,000 damages, is 10% at fault, D1 is 60% fault, and the D2 is 30% fault. Plaintiff's recoverable damages are $90,000.
Right.
Under joint and several liability, P can demand the full $90,000 from D1, even though D1 was only $60,000 responsible.
Yes. P can collect the full $90 K from D1 if D1 has the funds.
What happens then? Is D1 just stuck paying more than their share?
No, D1 isn't left completely without recourse. After paying the plaintiff, D1 has the right to seek contribution from D2. D1 can sue D2 to recover the amount D1 paid above D1's proportional share. In your example, D1 could seek $30,000, the share attributable to D2's 30% fault from D2.
Okay, so the burden of collecting from the other liable parties shifts from the injured plaintiff to the defendant who paid.
Exactly. It protects the plaintiff and ensures they get compensated fully and efficiently, while still allowing for ultimate apportionment among the defendants through contribution actions.
Has this rule also been modified in some places, like contributory negligence was?
Yes, significantly. Many states have reformed joint and several liability by statute. Some have abolished it entirely, making defendants liable only for their proportional share. This is called several liability. Others have limited it, perhaps applying it only if a defendant's fault exceeds a certain percentage, or only for economic damages but not non-economic damages. So this is another area where checking specific state law is critical.
Okay. What happens if one of the defendants is insolvent or just disappears? Can't pay their share. Under traditional joint and several liability, the plaintiff could get it all from the solvent defendant. What if joint and several liability has been modified or abolished?
That's so things get tricky. If liability is purely several and one defendant is insolvent, the plaintiff simply cannot recover that defendant's share. It's lost. Right. To address this, some comparative fault statutes include provisions for reapportionment of uncollectible shares. If a defendant's share is deemed uncollectible, due to insolvency, etc., that share might be reallocated among the remaining parties, including potentially the plaintiff if they were also at fault, according to their respective percentages of fault.
So the solvent defendants might end up paying a bit more than their initial percentage to cover the gap left by the insolvent one.
Exactly. It's another way to try and ensure the plaintiff is compensated as fully as possible, short of full joint and several liability.
Okay, that makes sense. All this discussion hinges on causation, showing the defendants actually caused the harm. You mentioned the but-for test and the substantial factor test. Can we quickly recap those?
Sure, the but-for test is the main test for factual causation. Ask, but for the defendant's negligent act, would the plaintiff's injury have occurred? If the injury would not have happened without the defendant's negligence, then that negligence is a factual cause.
Pretty straightforward if there's only one potential cause.
Right, but it can break down when there are multiple potential causes, especially if more than one act could have caused the harm independently.
And that's where the substantial factor test comes in.
Yes, it's used mainly in situations with multiple sufficient causes where two or more negligent acts combine, and either one would have been sufficient to cause the plaintiff's injury by itself.
Like the classic example of two negligently set fires merging and burning down a house.
Exactly. You can't really say that for fire A, the house wouldn't have burned because fire B would have burned it anyway, and vice versa. The but-for test fails.
So the substantial factor test asks,
It asks whether the defendant's negligent conduct was a substantial factor in bringing about the plaintiff's harm. If both fires were substantial factors, then both negligent parties can be held liable. It avoids letting both defendants off the hook.
got it. So once we establish factual cause using one of these tests, we still need proximate cause, legal cause. This involves foreseeability, right? And what about foreseeable intervening forces? Can something happen after the defendant's negligence that breaks the chain of causation?
Yes, an intervening force is something that comes into play after the defendant's negligence and contributes to the injury. But it only becomes a superseding cause, something that breaks the causal chain, and relieves the original defendant of liability if it was unforeseeable.
So if the intervening force was reasonably foreseeable, the original defendant is still on the hook.
Generally, yes. The key is whether the type of harm that occurred was a foreseeable consequence of the defendant's original negligence.
Give me an example.
Okay. Defendant negligently spills gasoline near a warehouse. It's foreseeable that spilled gasoline might catch fire. If someone carelessly tosses a cigarette nearby and ignites the gasoline, causing the warehouse to burn.
The person tossing the cigarette is an intervening force.
Right. But is a fire a foreseeable consequence of negligently spilling gasoline?
Yes. So the original defendant who spilled the gas could still be held liable for the fire damage, even though the ignition came from a third party's carelessness. The intervening force, the cigarette, was foreseeable in the sense that fire is a foreseeable risk of spilled gas.
What about medical malpractice? If the defendant negligently injures the plaintiff and then a doctor treating the plaintiff commits malpractice, worsening the injury.
Medical malpractice committed during the treatment of injuries caused by the defendant's negligence is generally considered a foreseeable intervening force.
Really? Even if the doctor was negligent?
Yes. The law recognizes that seeking medical treatment is a normal response to injury, and unfortunately, negligence can occur during treatment. So the original tortfeasor is usually held liable for the harm caused by their negligence and any aggravation of the injury caused by subsequent foreseeable medical malpractice.
Wow, that extends liability quite far. What about the subsequent injuries exception? That sounds related. It is. This deals with situations where the plaintiff suffers a second distinct injury later on because the original injury caused by the defendant left them in a weakened or vulnerable state.
Okay, how does that work?
The original defendant can be held liable for that subsequent injury if 1. The defendant's negligence caused the first injury, and 2. That first injury made the plaintiff more susceptible to the second injury, making the second injury a foreseeable consequence of the plaintiff's weakened condition.
So, like your earlier example, person gets a bad leg injury from a car accident.
Right, caused by the defendant driver's negligence. The leg injury makes their balance unsteady.
Then later, because of that unsteadiness, they fall downstairs at home and break their arm.
Exactly. The defendant driver could be held liable for both the initial leg injury and the subsequent broken arm. The fall and second injury were foreseeable consequences stemming directly from the weakened condition created by the defendant's original negligence.
That really highlights how far proximate cause can reach, connecting back to the original negligent act. This has been a really thorough breakdown of damages and defenses.
It's a lot to cover, definitely. These concepts are all interconnected. The type of damages affects the defenses affect liability, and liability determines who pays what. Understanding the whole picture is key for torts.
Okay, wow. We have definitely covered a ton of ground today on damages and defenses in negligence. And it was all thanks to Angela's fantastic notes.
Absolutely. We really need to give a big shout out to Angela. Her torts notes are incredible. They really make putting this podcast together possible.
They really do. All right, just a few quick housekeeping points before we wrap up, especially for all of you studying hard for the bar right now.
Good idea. What's first?
First, just remember, Angela's a student, just like you are. She's not an expert yet, and she hasn't passed the state bar yet either.
Right. And second, neither Angela nor this podcast, us included, are giving legal advice. Please don't construe any of this as legal advice. And, AI isn't a substitute for actually studying the law.
Definitely not. Third point, this podcast should be a supplement to your learning, kind of a review or maybe a different way to hear the material. It really shouldn't be the only way you're prepping for the bar.
Solid advice. Fourth, well, AI isn't perfect. Sometimes we might make mistakes. Angela does try her best to catch and fix any errors that might slip through.
Yep. And finally, fifth point, maybe the most important if you are studying in your car.
Oh, yeah.
When you're driving, please, the most important thing is to be safe on the road. Don't cause a tort while listening to torts.
Oh, good one. Seriously, though, stay safe out there.
Okay. And just a final reminder, if you want to reach Angela, maybe about her freelance law clerk work or just to connect.
Her emails are podcast@studyforthebarinyourcar.com.
And for the freelance work, it's hello@legalwriterandlawclerk.com.
All right, I guess this just leaves one thing.
Oh, no. Is it time?
As tradition dictates, time for our cheesy joke about damages. Ready?
Ugh. Okay, let's hear it.
Why did the negligence lawyer break up with the accident victim?
I don't know. Why?
Because he said, I just can't deal with all your emotional distress and non-economic losses anymore.
Oh boy. Okay, on that note, this is Claude and Maude, your AI bot signing off.
Thanks so much for listening. Bye.